Hi, this is Kurt Doolittle from Propertarian Institute. I want to do a little piece on the high-level piece on the law, in the sense that what is it about our Constitution that needs to be altered or improved in order to restore its original intent. I'm going to cover quite a few points here. I hope this doesn't wear you out. First, judges are forced to adjudicate between customary judge-discovered law, what we call regulation, and what we call legislation, and sometimes what we call command, during a period of rapid social, economic, and political upheaval. The state has taken on a monopoly of the application of violence and created a monopoly method of dispute resolution, the courts, and created a monopoly body by which to adjudicate such conflicts, and we call these law, legislation, and regulation. Now, there exists only one universal law of human cooperation. We call that law natural law, and that natural law consists in reciprocity. Reciprocity requires satisfaction of the criteria: A, fully informed; B, productive; C, warranted; D, voluntary transfer; E, free of imposition of costs upon the interests of others by externality. One can obtain an interest by bearing a cost, performing an improvement, meaning for the purpose of obtaining that interest, and one can have no interest until one has borne a cost to obtain such an interest. This one law, reciprocity, provides decidability independent of opinion, preference, custom, or presumption of good, and is the reason international law is governed by reciprocity. It's the only rule that provides reciprocal, meaning equal incentive against retaliation for the imposition of costs upon one another. So law evolved from the very first record to the present for the purpose of preserving the volume, velocity, and returns on cooperation, and preventing cooperation's opposite, retaliation cycles that throughout history have produced the deleterious effects of feuds. Well, this happens at every scale, right? I mean, there's reciprocity between individuals, there's reciprocity between groups, there's reciprocity between nations, but the said general problem is the same, with the only difference being that within groups we tend to produce very elaborate, we call them social contracts, or I would say that's kind of an overstatement. They're actually norms. And these norms are usually reflection of the needs of whatever our means of production is, given the geography and demographics we're dealing with. So within a group we have a bunch of norms or rules, and those constitute a set of recommendations or orders that we generally adhere to, and then the law resolves disputes within them. So while interpersonally and intergrouped internationally, we are very strict with reciprocity. When it comes down to social matters or political matters, it's this elaborate network of norms and all the contractual exchanges that have to be weighed within them. Next, customary law, especially Germanic, if not all European, consists of the discovery and accumulation of applications of this one law of reciprocity. We call it tort law. Legislation, or possibly command, and regulation, prior constraint, have been given the force of law by those whose profit interests, either the population, which tries to preserve the returns on cooperation, or the territorial rulers, which try to preserve their returns on taxation. So it's been given the force of law, but it is not law. Law is only that which is discovered by judges, that is the record of applications of the test of reciprocity on our interactions. The primary function of rule has been of what we call rule is the preservation of cooperation by the organized use of violence to suppress impositions of costs on the investments of others. This is the role of insurer of last resort of personal interests. The primary function of government has been the construction of commons and the extraordinary returns produced by commons, while ensuring those commons from privatization of those commons, socialization of losses into those commons by the same organized use of violence. This role of government is as insurer of last resort of the commons. The primary function of the state, particularly with the advent of paper currency and now fiat or unbacked currency, really our money consists of nothing but shares in the economy, and it's backed by nothing other than that economy. This has increasingly evolved to function, in other words, the state has increasingly evolved to function as insurer of last resort against the hazards or the vicissitudes of nature, which includes things like tragedies, disasters, accidents, disability, health, old age, and even war. So the state's primary function has been the insurer of last resort against hazards. So between rule, the insurer of last resort against personal interest, the government, the insurer of last resort against the commons, and the state, the insurer of last resort against hazards, we've produced basically a government that consists largely of an insurance company. This is why regulation is so important, and it produces prior constraint. This prohibits us from taking risks that could be expose others to harm. In general rule, the general rule of reciprocity is you can't take any action you can't perform restitution for. So obviously death is something you can't perform restitution for. You can't bring someone back to life, at least we can't yet. And reciprocity demands a restitution. So for example, the state regulates who can enter into some markets by requiring that they have some modicum of education or training, so that the public isn't victimized by constant new entries of people whose performance is unpredictable, and the restitution for which they cannot pay. In other words, when they can't pay restitution. So. Now let's get into rights. Rights can only exist A, by a reciprocal exchange of the same obligation. In other words, we can only have a right if you and I change it. In other words, I'll grant you a right, you grant me a right. We can exchange that right, but when we do that, we also exchange an obligation. I have the obligation to respect your right, and you have the obligation to respect mine. So that's what those rights are the outcome of a market exchange, but they also have, in order to be enforced as a right, they have to be insured by a third party with sufficient organized violence to ensure and enforce them. It's common in libertarian cycles to pretend rights somehow exist prior to this, or the demand for a right is the same thing as the existence of a right, and the same is true with the left. The left says everything is a right that could be possibly wanted. In other words, their view of right isn't reciprocity. Their view of right and wrong is equality, regardless of cost to the other people. So a leftist is happy to impose costs upon others, where a conservative and a libertarian are not happy at all to impose costs or have costs imposed upon them. Now, human rights consist of ambitions that we demand from governments of states in order to tolerate their retention of a monopoly of control over territory and the people. In other words, in the post-war period, we have granted other states sovereignty on the condition that they work to produce human rights. Basically as a self-defense mechanism. They exist as a post-war attempt to constrain governments to improving their territory, people, and assets by market means without imposition of cost upon their neighbors. I mean, most of the agrarian era, the only way you can improve your condition is by expanding your territorial holdings, and therefore the control over the direction of proceeds from production. What we've done since the First World War, and the idea in the First and Second World War is, well, let's never do this again. Let's hold people. Let's get together states, so we hold other states accountable for acting within their borders, and that's the means by which we let them govern. Unfortunately, the United States is the world's enforcer of this, and throws out these wonderful carrots such as self-determination and human rights, without saying, well, if you enact a government that violates these rights, we're going to punish you for having made that decision. So that we don't talk about the stick, unfortunately, and that's really been the concern, because communism was an expansion of the left's method of imposing costs on other people, rather than an expansion of the market, which we have struggled to rebuild between the fall of the ancient world civilizations and the rise of modernity. Now, human rights, as I said, consist of demands for the states. These exist but the Universal Declaration of Human Rights contains a few provisions that were necessary at the time to exchange the signatures of the then communist states. Those states that the communist states, didn't assert natural rights of reciprocity. They asserted the negation of those rights and asserted positive rights instead. So you'll find the last, I think it's 3 clauses of the International Declaration of Human Rights are basically forcible communist additions. Well, they can't be rights and they can't be imposed, so they're just merely ambitions that we would hope to search for. Where was I going to this? So the Universal Declaration of Human Rights contains a few provisions that were necessary to obtain those signatures that asserted positive rights, obligations to provide for one another without constraint on the reproduction that exhausts the ability to provide for others, and therefore results in gradual dysgenic decline, and as we reverse thousands of years of upward redistribution of reproduction back down to the underclasses, who are now not able to produce sufficient market goods. In other words, we've gone down to the bottom and we've taken them off the farm, and their subsistence living, and we've also put them in a position where they're no longer able to produce anything of any market goods because they have not the skills or frankly the abilities to produce goods services and information to compete in the market. Our American Constitution persisted the original Anglo-Saxon, Germanic, Proto-Germanic, and I suspect Proto-Indo-European Proto-Indo-European law of sovereignty, that sovereign men were limited to acts of reciprocity and licensed any and all government or leaders. The idea of government is a relatively new thing as we understand it, but they licensed rulers to act in their interest, to preserve their sovereignty. The original text of the Constitution actually being life, liberty, and property. I'm not quite sure why that was changed. I know when it was changed, but I don't know the debate behind why. Unfortunately, at the time that the Constitution was written, the techniques of formal logic, strict construction from first principles weren't really known. That's really an artifact of the experiment with logic in the 20th century. There are pretty strict constructions. If you look all the way back to Spinoza, he does a wonderful job, and of course Kant does a fairly good job. But law hadn't been yet reduced to a formal logic at that time, so strict construction wasn't possible. But we're no longer limited as they were. We know those things, and we know the first principle of reciprocity. So there's no reason any and every law can't be constructed formally from the natural law of reciprocity, producing a complete, consistent, and easily falsifiable body of adjudicatable law. There's no reason any and every act of legislation, which should be considered a contract, and every act of regulation cannot also be constructed from the first principle, strictly constructed from the first principle and of reciprocity. The principal difference under such formal construction is that the one law of reciprocity and the discovered application of the one law and regulation to limit hazards of those actions upon restitution and the contracts for the production of commons would be all consistent, and as such the government can only issue contracts under law, not edicts above that law. And if we had this strict construction, you would find that not only would judges not need to interpret the law, they could specifically say why the law did or didn't cover it. This would, and furthermore, you couldn't produce all this incrementalism and all this fuzzy law we put in place like the famous let's pass it and then understand it. This would really destroy the left's ability to usurp power by democratic and legislative means, and it would further destroy the left's ability to continue to undermine our natural law, Constitution, by forcing decisions into the judiciary. Well, at least part of it. The rest of it's going to come in. The rest of it I'll explain in a minute. Now, to give some background, the uniqueness of Western civilization is reducible to A, a militia that constitutes the shareholders, B, the individual sovereignty of those shareholders, C, the demand for truth, duty, and reciprocity from one another in mutual insurance of our sovereignty, and D, the dependence upon a jury of those sovereign peers for adjudication of the differences, with judge as the referee. What you hear here is a bunch of equality, really. And sovereignty results in the necessity of markets for association, cooperation, reproduction, production, commons, and polities. And lastly, score F, such markets adjudicated by the law of the court adapt to change faster than all other methods of human organization. And G, it's this rapidity of adaptation and resulting insulation from corruption and rent-seeking that made the West not develop first, but develop faster than the rest of the civilizations in both the ancient world and the modern. Now, with the unfortunate exception of the Abrahamic Dark Age of the Jewish, Christian, and Muslim attacks on the great civilization, providing the only hindrance. That Dark Age really was a hard time, and we had while I understood the Dark Age to be 1,000 years, I think it really goes from much earlier than we thought to really the time of Napoleon, because only France basically is able to restore the same level of order and trade and infrastructure that Rome was able to produce. Now, however, once during the Dark Ages, finally it took the North Sea trade reestablishment. In other words, there was always a trade route from the north of Italy across the continent and somewhat around the continent. But by the High Middle Ages, the Germanic colonies were able to, especially Saxons in particular, Saxons were our version of today's Jews, they were able to create a high trust trading system across most of the original Europe, the North Sea Baltic area, and the continent. And then when the Atlantic opened up during the Age of Sail, this brought even more wealth and somewhat put the emphasis back on the emphasis of growth and innovation back on the seagoing powers, and delayed and held static for a while the Germanic expansion that had really brought about the restoration of commerce in Europe. This is all going on at the same time. There's really three motions, right? There's the trade from really Venice. The Venetian trade is acting as the navy for Constantinople. This is producing a trade route across Europe, but Europe is still not able to produce a very as complex a trade network. The Vikings come around and establish one. The Germans come around and establish theirs, and the Atlantic comes around. And eventually, by the High Atlantic period, late 1700s, we are beginning to return ourselves to Roman levels of development. So I want to point out that, or make a note that the West had fertile lands and forests, but no flood river valleys. And when you get a flood river valley, you can concentrate production. You can around that flood river valley. You can basically build it around your infrastructure is your means of irrigation, and because of that means of irrigation, the control of the irrigation, and the adjudication of that irrigation, you can put together taxation upon the production of those in a very basically you have a concentrated means of production that can be taxed. The problem for Europeans is while you had very good land, it still had to be run as individual farms, and And this is particularly true because the winters are fairly hard, and so while you can bring in slaves, there's you don't have the luxury of warm weather to hold people, or as many seasons of harvest to hold people over. This is why people used to talk about Egypt, because it's the place where there was food. And so while the ancient world could form armies, Western people had to form militias, small groups that relied on advanced professional warriors. Then they used quite a bit of technology, and they took bronze wheel horses, and it was expensive. So whole families were required to pay, and their landholdings were required to pay for it. So these militias, which is a nice word, let's call them what they are: cattle raiders, sea peoples, Vikings, pirates, and European explorers, organized expeditions or raids on each other, frankly, mostly, but then expanded it to others, and it was this militial order, or this entrepreneurial order of military engagement that led to our sovereignty law contract and debate, and and eventually in the Greek world led to from law to reason, from reason philosophy, from philosophy to science, and finally if we get Aristotelian science or Aristotelianism, let's just Aristotelian thinking, we get Stoic, basically religion or mindfulness, and we get Epicureanism as the competitor to it. We've actually reached a fairly high point in human development. Unfortunately, had the Roman not overextended, it looks like at least the Greeks might have stumbled upon the industrial age back then, but instead we invaded the Middle East, were infected by the Middle East the same way the Greeks were infected by Alexander's conquest and their mysticism, and we had our overextension in our 1,000 years of dark ages. But the point I want to make here is that it's not like some brilliant choice of Europeans. We just happen to have these conditions during the Bronze Age, put together horse, cart, wheel, and bronze, and made ourselves chariots. And from then on, it was pretty much a rapid expansion and a conversion of civilizations from the maternally driven earth worshipping to the paternally driven sky worshipping. As you can see in certain parts of the Bible, still you can see the combat between Cain and Abel is a combat between the farmer, who's using technology and cities, and the shepherd, who the father wants to. In other words, this debate between Semitic pastoralists and Semitics and their pastoralists and Semitic-speaking pastoralists and the aristocratic farming civilizations has been going on a very long time. So I'm trying to get that uniqueness. I hope I got that uniqueness around us. Just as always, geography, economics, and demographics. Geography, climate, economics, and demographics produce the civilizationals that we see today. Now, progressives lie to mask what's merely theft. This is their whole thing. They rely on postmodernism, which was just lying by sophistry. They rely on Marxism, which is sort of pseudoscientific sophistry. They rely on Freudian psychology, which is a complete pseudoscientific sophistry. They rely on Boasian anthropology, which is again is a pseudoscientific sophistry. And so, yes, the progressives have built all these comforting lies. But conservatives, on the other hand, can't tell the truth. And that's because the truth is really quite simple. The reason for the success of Western and Eastern civilization and most obviously the Ashkenazim, is that the upward redistribution of reproduction and the use of manorialism and taxation to limit the reproduction of the underclasses until such point that the surpluses are sufficient to continually increase the standard of living through continuous market competition and innovation. Man wasn't oppressed. That's the unfortunate lesson the progressives don't want to hear, and the unfortunate thing that the self-aggrandizing conservatives don't want to admit is that man wasn't oppressed. Man was self-domesticated through the same process he used for plants and animals, breeding the best and culling the rest. And that's the dirty secret of Western and Eastern civilization, is that our demographic distributions aren't so much that we're superior in some way. It's, well, I mean, I'm not going to get into that, but I mean, I would say it's not necessary for anybody superior in some way. It's just that there's the bottom has been truncated by nature and political order. And so that's the dirty secret of the successive civilizations, and the one that nobody wants to face. It certainly contradicts our message of universal democracy and the Anglo-Enlightenment fallacy of an aristocracy of everyone. I mean, that's insane. It's true that in Europe, by the time we get into the late Middle Ages, pretty much everyone's descended from the genetic middle class because of this process of eugenics, including our aggressive hanging of malcontents for 1,000 years. So we can't say the truth. I mean, it's contrary to, if we'd had a retained aristocracy and not the middle class hadn't lied as a sophisticated means of overwhelming the aristocracy, and the aristocracy had been a little bit smarter about understanding how to control, how to maintain traditional control and at the same time allowing the middle class the rising middle class which is now more productively important, then we could have possibly preserved our system of government without having the great fantasy of the great movement against Darwin and eugenics come into play. So what's happening now is that we have genetics, and we have the evidence of democracy, we have the result of the world and the carrying capacity of the world, and this is, at least some people understand this. The Chinese certainly understand it because they're facing it at home, and so they've been acting on it at home. Because really China is just a skinny, sort of like California, a strip of green along a desert. And so they've been working on it, but in the West we're still utopian, possibly because we are consuming this wonderful pair of continents, or 3 continents we've discovered. So again, sovereignty. So this is the dirty secret, and to continue it, to repeat it, sovereignty, truth, duty, and reciprocity produce markets, and markets are eugenic. They're just a peaceful form of eugenics rather than war, enslavement, and serfment. But by use of sovereignty, truth, duty, and in other words, the left is right in that they're just serfs. I mean, it's true, but they're serfs that are actually have actually weaponized their reproduction to undermine what has made their condition as free serfs versus literal slaves versus the people who are exterminated. I mean, they're undermining that. So the Chinese, sovereignty, truth, duty, and reciprocity in markets, these are eugenic, and they're just peaceful eugenics. By the use of sovereignty, truth, duty, reciprocity markets, Western man in both the ancient world and the modern has just dragged humanity kicking and screaming out of ignorance, superstition, hard labor, poverty, starvation, infant mortality, early death, disease, the vicissitudes of nature, and just about every harm that can come to it, because we have built these wonderful markets that are productive enough that states can act as insurers of last resort against most of these things. But the Chinese are not as inhibited we are. They do care about markets other than their ability to preserve their, they don't care about markets so much as their ability to preserve their racially homogenous polity and return themselves to a position of world power to do so. Their thing is harmony. They're a static civilization, and they don't practice truth whatsoever. It's very, they have a problem with truth and corruption. And on levels that, even the Russians would never dream of. I mean, it's unbelievable. But we're just the opposite. Excuse me. So they're actively researching methods of direct improvement, while even their one-child policy didn't help the ongoing decline in the distribution of intelligence. They're having a decline. But we're doing the opposite, which is deliberately undermining the very reason for evolutionary success, the means by which we again dragged humanity out of darkness. And we're doing it through through immigration of those very peoples who we spent thousands of years eliminating from our polities. As far as I know, Anglicans and Ashkenazim remain in relative parity, although the Ashkenazim have a much wider distribution than we do, and they produce more outliers at the very top of the range. But the Anglos otherwise have lost a full standard, other than the Anglicans, have lost a full standard deviation or more since the beginning of the Industrial Revolution. Now, even the Norwegians are starting in on a distributional decline in IQ. And this is because if we don't maintain the upward distribution of, basically, we don't evolve and maintain the upward distribution of ability by reproduction, and we again reverse it, all we do is make it harder for us to produce returns that make standard of living possible. In other words, it's more of a knowledge, our Malthusian problem isn't so much bound by land anymore as bound by demographics. So the most profitable action any polity can take is to institutionalize benevolent eugenics, and that is to pay the underclasses not to reproduce and to limit all immigration to skilled professionals, and to push the young and old into the labor force in the less demanding occupations, just like we did throughout all of human history. This is the lesson of our experiment with universal democracy and Marxist postmodernist globalism, the dramatic reversal of centuries of civic improvement and the turning of the developed world into another Levant. South America is already there, but the Levant has been there since the, if not before the Arab conquest, certainly since then. At present, only the East Asians are willing to pay the costs of retaining their accumulated genetic achievements. The eugenicists were certainly right, and in retrospect, it appears that Bose, Marx, Freud, the Frankfurt School, and the French postmodern movements were nothing but counter-reactions against Darwin, Maxwell, Menger, Spencer, and Nietzsche, the same way that Judaism, Christianity, and Islam were reactions against the old world's market aristocracy. And the entire post-war period has been nothing but a pseudoscientific and pseudo-rational attack on Western civilization in an effort to repeat the destruction of the civilizations of the ancient world by the same means. False promises. Simple people and false promises. This time they're using pseudoscience and pseudo-rational sophisms using major media instead of supernatural sophisms using Roman and Greek writing. And apparently, if I look at the voting data, we can look at it pretty obviously, it's primarily by obtaining the votes of women. White women being the only defectors among the racial groups. I'm going to I've gone through this. I've gone through really the competitive importance of the Western tradition and its demographic effect on us. And now I want to come back to the Constitution a little bit and our law. And I want to say it's really simple: life, liberty, property, and reciprocity. The Constitution defines how the government, which means production of commons, is organized. And in this case, it defines how the judiciary is organized, as well as the Constitution. It has a little bit in there of insurer of last resort provisions, but that really is a function more of the later 19th century. The Bill of Rights defines the law that may not be discovered. Defines the law that may not be discovered, legislation, regulation may not be passed. In other words, it says what you can't do. The Constitution does try to implement natural law, life, liberty, and property, but it does not state such concretely in the Bill of Rights, nor does it state the law of reciprocity, despite the fact that reciprocity is the basis for the common law back into prehistory. Now, we could quite easily reorganize the Constitution of life, meaning existence, liberty, meaning action, and property, meaning things, and reciprocity, meaning volition, and then tie every one of the articles and amendments back to these three, reciprocity, the three dimensions of its demonstration. This set of three rights, existence, action, and possession, and the single law of reciprocity are very simple criteria which any constitution can be strictly constructed from. Now, we run into the problem of originalism and textualism. Now, originalism requires that the legislature alter the law and that the court not alter the law, only reject bad law. And the Constitution was an attempt to codify that natural law of reciprocity, and our natural law has been basically of reciprocity or tort has been around for 3,500 years. The weakness of our system of government is there's no requirement that a law pass the court before it's enacted. In other words, there's no gate, legislative gate, there's no juridical gate to legislature. In the British system, they retained the House of Lords pretty much as a gate on the constitutionality of their system, and then enacted the natural law. And at this point, they've probably followed our bad example and gotten rid of it. But at present, there's no requirement that a law pass the court before it's enacted. In other words, there's no requirement that it pass judicial scrutiny. This is not in Rome. Rome in particular was very interesting in how they did this with, basically prophets of the law. And there's no way for a court to compel the state to repair a law. Compel the state, meaning the legislature, to repair a law other than to invalidate a provision or all of it. And the statement of natural law of reciprocity, original textualism, and strict construction from natural law of reciprocity were just not stated as part of the document, and so law could not be logically consistent, or we would say, because law is actionable, it can't be algorithmic. And it couldn't be algorithmic. Wherein the truth is that these confusions wouldn't be necessary if we had a clearer statement in formal language in the Constitution originally. Now, we really have these three documents, right? So I'm going to go over that next. So what is the proper method for the Supreme Court's decisions? For example, here's a quote, is that the constitutional doctrine of separation of powers mandates the judges anchor their analysis to the text as reasonably understood by the people at the time. That leads to a violation of reciprocity, meaning natural law. If that leads to a violation of reciprocity, natural law, then the proper avenue for redress is to amend the Constitution so the text better codifies reciprocity, natural law. Now, I assume the minority of strict jurists assume that the founding documents consist of the Declaration, Constitution, of Bill of Rights. And that's because you actually have to have all three of them in order to put together the argument. I would argue that you need the three of them and the Federalist Papers. Without the three of them and the Federalist Papers, it's very hard to, our Constitution is not strictly enough constructed. It's a reasonable document, but not a logical document in the sense that it's reasonably consistent. It's not a constructivist document, and that it's formally constructed. So, where was I? Assume the minority structures consider the Constitution, the Declaration, and the Bill of Rights. And if clarity of original intent is required, then we resort to the Federalist Papers or the notes of the proceeds of the debate. Once the Bill of Rights was ratified, then the founding documents were complete. In other words, it took those three documents. Now, this is important because the natural right, the Declaration is an appeal to natural law. The Constitution describes the organization of the government, and the Bill of Rights attempts to codify and enumerate those violations of natural law. The problem is they don't state the positive. In other words, it doesn't state all law shall. So unfortunately, first, reciprocity isn't specifically stated as the first rule of natural law. Second, there is no requirement that the judiciary certify the constitutionality of legislation, and instead all legislation ascends until falsified by the court. In other words, the market has to test the legislation. If conflicts arise, the court corrects the legislation. This is the issue. This approach continues the This approach continues the no prior restraint of the Anglo-Saxon Germanic law versus the prior restraint of continental, meaning French and Roman law. And this is yet another example of markets and everything. The difference between American and Anglo law and continental law is largely this difference in prior constraint on the continent and post-resolution in Anglo law. In other words, we're a more permissive and experimental law, and we resolve conflicts. This is a more experimental way of working world, and the continent is more conservative. Okay, it's more provincial. Worse, without specifying reciprocity, there's no means by which the initial rights can be limited, and therefore no means by which the court can limit the grant of rights rather than permissions and obligations. Worse, there are no means by which the court can return the legislation to the legislature and demand correction. There are no means by which the court can suggest corrections or amendments to rectify the deficiencies and return to the legislation. As such, the court must, and the president must choose line item veto, so to speak, or to veto the entire piece of legislation, so that's what the court does. Worse, the court members use different criteria for determining the power of the legislature. And first, we have the rule of law, which is the substantive version, in which the legislature and people may only act in concert with natural law. That's my view. There's rule of law, which is the formalist interpretation, which the legislature can do what it wants, which tends to be the more it seems to be the middle of the road position. And lastly, the unfortunate majoritarian, which is really a result of the attempt to undermine the law, and which the people via the legislature can do whatever they want, regardless of whether it violates the natural law. In other words, there are always three parties to a matter before the court: the plaintiff, the defendant, and the legislature. And the court can't demand remedy of the legislature, and that is its oversight. All right, now I've gone on for 40 minutes, and I've tried to cover the very high-level problems with the structure of our law, in that the origins of it, the result of it as a eugenic system, and the moral outcome of that eugenic system, and the weakness of the insufficiently formal construction of the Constitution, and the primary means by which our constitutional process fails, which is that we have a lack of clarity in what the limits of the people and the legislature are, and we have a lack of clarity on how to fix the problem of regulation, legislation, and even findings of law that are undecidable, and there's no means of correcting them because bad law can get out there, get institutionalized. There's a wonderful quote which I'm trying to recall relatively quickly, which is that science evolves with the death of the people who held the last paradigm, and bad laws tend to be immortal. So my other view would be that just as all contracts must have an expiration date, and it can only be so far in the future, all legislation and regulation must have an expiration date, which can only be so far in the future. It's this this dependence on traditional law without articulating the formal construction of that law as reciprocity that makes it possible, that gives extended life to the problem of the old laws. In other words, nobody takes the effort to go back and get rid of old laws, and nobody takes the effort of going through laws and actively saying this needs to be taken before the court and resolved, because there's just no process for doing it. Anyway, this is Kurt Doolittle for the Propertarian Institute. That's my high-level, one of my first high-level pieces on the law. I hope you found it informative. Thanks a lot.